Terminating a residential building contract in Queensland is one of the highest risk decisions a homeowner or builder can make. It is rarely straightforward and mistakes are expensive. There are only 3 lawful ways to terminate. First, termination under the contract. Second, termination at common law for repudiation or breach of a fundamental term. Third, termination by mutual agreement. Anything outside of these pathways is legally dangerous. Most residential building contracts require strict compliance before termination. That usually means identifying a specific breach, issuing a written notice that complies with the contract, allowing a defined period to remedy that breach, and only terminating if the breach remains unremedied. Skipping a step invalidates the termination. Common law termination applies only where the breach goes to the root of the contract. This includes abandonment of works, refusal to perform, insolvency, or conduct demonstrating an unwillingness or inability to complete the contract. Delay, poor workmanship, or defects do not automatically amount to repudiation. Misjudging this threshold is common and costly error. Termination by agreement avoids dispute but must be documented carefully. Outstanding payments, defects, access to site, materials on site, and final accounts must all be addressed. Informal or verbal agreements create future litigation risk. Wrongful termination flips liability. A party who terminates without lawful grounds may be treated as the repudiating party. That exposure includes damages for loss of bargain, completion costs, delay damages, and potentially legal costs, far exceeding the original dispute. After termination, rights do not disappear. Final accounts must still be prepared. Claims for damages, set-offs, and completion costs require evidence. Statutory obligations under Queensland legislation continue to apply. Termination is not an average tactic. It is not a disciplinary tool. It is a legal endpoint with immediate and irreversible consequences. When termination is invalid, it usually destroys the terminating party's position. Click the link and contact our building and construction professionals for a free 30-minute consultation and let us help protect your rights.